Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and our recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with the contact information you'll see on the last slide. This is just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website, so please visit us there. We do offer advertising, so you can email this email if you'd like more information on that. All right, our speaker today is Devon Hewitt. She's going to be going over debriefings, what you can and cannot ask. Thank you for joining us, and I'm going to go ahead and hand it over to you.
Thank you, and thank the attendees for listening in. I just completed a webinar on timing of debriefings, and this is a natural follow-on on what you can and cannot ask in a debriefing. I'll just recap very quickly that on timeliness or timing, in order to get a debriefing, you have to request one within you have to request one in writing within 3 calendar days. And the government's only required to give you a debriefing in certain types of procurements. So those are the 2 things to keep in mind. If you receive a debriefing, the question really isn't what you can and cannot ask. The question is, what is the government going to tell you? You can ask any question you want, but is the government going to answer that question? And can you follow up? Or what questions you should ask to prompt the government to give you information that you might think is useful? The type of questions you ask really depends on your strategy for the debriefing. The conventional wisdom is that you ask for debriefings in order to learn how you can improve your proposal the next time. And the government holds debriefings to give you the opportunity to learn what they thought were strengths and weaknesses of your proposal. But there are a number of reasons to have a debriefing. The other reason that's probably the most common is to learn information about the procurement, about the evaluation of your proposal, the evaluation of the awardee's proposal, and see if those facts suggest to you that a protest is warranted or that something was done improperly, or certainly not like you anticipated from reading the solicitation. But you also can have debriefings because you want to use it as a marketing opportunity. You want to introduce yourself to that agency. You want to show that you're a professional organization, knowledgeable about the area. You could highlight certain aspects of your proposal that are positive and then maybe use them as a foundation to ask, well, why did you not think that was a particular strength? Or is that something you've seen before? Or you could just have an informal repartee to make it more of a nice touchy-feely experience. So there are a variety of reasons to have a debriefing, and that is going to govern the questions you might want to ask. The FAR, the Federal Acquisition Regulation, which applies to federal procurements, where there is a required debriefing, the FAR is required to provide responses to quote-unquote reasonable questions raised by the debriefed offeror regarding quote-unquote whether source selection procedures in the solicitation, applicable regulations, and other applicable authorities were followed. Next slide. Next slide. In this regard, the FAR lists the information that the agency must provide during a debriefing. And of course, a debriefing can be pre-award and post-award. The information that the agency generally and readily discloses is information regarding the evaluation of the debriefed offeror's proposal. And that would be the identification of significant weaknesses or deficiencies in the offeror proposal, the overall evaluated cost or price of the offeror proposal, and that applies depending on the context of the procurement. If you had a cost reimbursement contract procurement, then the evaluated cost would be appropriate. If it's a fixed price, the price, unless you have a price realism issue, and then it might be whether or not the pricing was considered reasonable or realistic. The agency is also supposed to disclose your technical and past performance ratings, although they will not identify the names of the agency personnel who provided past performance references. I think they're worrying about revenge or something like that. And with respect to the technical ratings, the FAR doesn't specify whether the technical ratings apply to overall ratings, sub-factor ratings, or factor ratings, so keep that in mind. The government agency is also supposed to disclose a ranking if one has been developed by the agency, and a summary of the rationale for award, quote unquote. And that's the one that a debriefed offeror really wants, and that's the area in which a debriefed offeror is generally left wanting. Next slide. And the reason for that is that the FAR also instructs agencies to refrain from providing a certain amount of information. Agencies typically will not provide information regarding the agency's evaluation of other offeror proposals, except for the overall evaluated price or cost of the awardee's proposal. And generally, you get that in the notification of award as opposed to the debriefing. And they might provide technical ratings of the awardee's proposal, although that is not mandated, but it often is provided. And if it's not provided, that's a question you can ask. The FAR explicitly prohibits an agency from doing a point-by-point comparison of your proposal with the awardee's proposal. So, for example, whether or not you got a weakness in a particular technical factor and did the awardee get the same weakness, or you got 3 weaknesses and got a satisfactory, how many weaknesses did the awardee get under that factor, and did they get a satisfactory or very good? So anything that's a comparison, the agency will not do during the briefing. And of course, they cannot disclose trade secrets, confidential, proprietary or financial information, which means they really can't disclose anything in the offeror's proposal, because if you're like most offerors, you put the restrictive legend on your proposal indicating that everything in the proposal is proprietary, confidential, and financial information that shouldn't be disclosed outside the government. So the restrictions above really make it very difficult for the government to give a useful summary of the rationale for award, particularly in the best value procurement when there's a cost technical trade-off. They could give you the overall cost, and they might give you the technical ratings, but in protest law, particularly at the Government Accountability Office, the best value trade-off is not supposed to depend on the overall price and just the ratings. It's the information behind the ratings that's really important for source selection. But that kind of information you're not going to get in a debriefing typically. So that is a reason to ask questions. And as I said earlier, the FAR does require, does require the agency to provide responses to quote-unquote reasonable questions regarding certain areas, and it's compliance with law and regulation and making sure the evaluation is consistent with the solicitation. That's very vague, and so that can be interpreted narrowly or broadly depending on the agency that is holding the debriefing. Next slide. Now, DoD agencies, under something called the Enhanced Debriefing Rules, they provide, are supposed to provide, if the offeror is a small business and the value of the procurement is between 10 and 100 million, a redacted copy of the source selection memorandum, and then to provide that to all offerors if the procurement's valued above 100 million. This came out of the National Defense Authorization Act of 2018. However, what DoD is saying is that this part of the enhanced debriefing, not the timeline for asking questions, which we discussed in the earlier webinar, but this part of providing the source selection decision, the DoD says it won't do it unless that the FAR, the DFARS, is actually amended to reflect that, and it has not yet been amended, although my experience certainly recently is that the defense agencies pretty much are readily supply the source selection document or memorandum, and if they don't, if you request it, they provide it. Now, it is redacted, so in some ways you're back to where you started because they can't release in a debriefing all the things we talked about, and that can't be released in the source selection document. And so really what you're going to get is more information or the same information about your evaluation of your proposal than you got in the earlier written debriefing. But the DoD agencies in this enhanced debriefing state of the world does allow explicit time to ask questions, whereas with civilian agencies, the civilian agency, if it provides you with a written debriefing, may consider that debriefing concluded, even if you follow up with questions, which is really only important if you're considering a protest. So that's just something to keep in mind. Next slide. So in addition to asking questions about the evaluation of your proposal, and as I said earlier, agencies generally and readily provide information about the evaluation of your proposal, the FAR allows an offeror to ask reasonable questions regarding the process. And so here are some examples of what those type of process questions would be. You know, were all proposals submitted on time? Did the agency develop a ranking? That was something that they're supposed to disclose. You know, were there any agency communications with offerors after submission of final proposal revisions? The type and nature of questions that you ask, of course, reflects your strategy for holding the debriefing. And I'm going to assume for purposes of this webinar that the purpose of the debriefing, in addition to learning how you can improve your proposal, is to gather information to see whether the evaluation and the procurement was conducted properly, and if not, whether a protest is warranted in this situation once you learn more facts. Next slide. So I've listed here a number of questions in the following slides about questions that a debriefed offeror ought to consider asking, particularly in mind of filing a protest. And some of them are apparent when you read them. Others are not so apparent, the reason why you would ask that question. So I'm going to try to explain why I advise my clients to ask these types of questions. The first seems obvious. Ask what the significant strengths or weaknesses the agency identified in its proposal. I added here weaknesses and strengths and significant strengths because typically the agency is only required to disclose significant weaknesses and problems that your proposal had, and they might disclose significant strengths, but they may not mention that you also had strengths or you also had weaknesses. I mean, it's just hard to know what you don't know. So most evaluations are conducted using these criteria. So significant strengths, weaknesses, significant weaknesses, and also deficiencies. If you have a deficiency, you're likely to know that sooner rather than later, but maybe you got a marginal or unsatisfactory rating that typically reflects a deficiency. So ask pointedly if the government hasn't classified the information in all these boxes. So ask to make sure there's nothing else that might be relevant. Again, I mentioned that they might give you a technical factor rating, but you may know that there were sub-factors that you had to address in your proposal. There might be an overall factor There might be a past performance factor that is or is not in the solicitation within the technical factor. You might also ask information regarding the weighting. There usually is a weighting described in the solicitation. You'd like to confirm that that weighting was followed, and maybe how they did that weighting. Was it a point score? Was it adjectival ratings? Back in the day when I started doing this work, it was points and more objective scoring, but that made the agencies more vulnerable to protest because they made mistakes. Defense agencies and generally a lot of civilian agencies as well are using now these adjectival ratings along with colors. And if anything, I think that's just to give them the sort of flexibility that makes it difficult for an offeror to protest and say, I should have been above the 90% threshold instead of below. It's harder to argue you should have been blue rather than green. So you want to do a checklist of everything that's in the solicitation. Were your costs realistic? If it was a cost realism, were your prices considered reasonable? What was the price? What was the estimated cost? When you're talking about past performance, they consider all your references recent, relevant, whatever the criteria were in the solicitation. And you just want to do this checklist. Typically, the agency's done that checklist, and this is easy information for them to provide. But it's good to know and track it against the solicitation, because sometimes they will give you significant strengths, but forget that you also had strengths. Or the same with weaknesses. You have significant weaknesses, but you may have also weaknesses. And all information is information, which means all information could be useful or not useful if you're thinking about a protest. Next slide. Again, more questions that are relevant to past performance. If you had proposed subcontractors, did they consider that past performance? Some solicitations say the agency will only consider it if the subcontractor is performing more than a certain percentage of the work, or they will only consider it if the past performance is relevant to the work that you're proposing the subcontractor do. Joint venture partners, again, that's important. It's particularly important in small business procurements because there's actually a regulation that requires agencies to consider the past performance of each joint venture partner. And some of these questions are just, sort of questions throwing a rock across a pond just to see what comes out of it. You can't really know the significance of some of these questions until you hear the answer. So, did the evaluators reach a consensus? Was there a dissenting opinion? The last question here is, you always ask whether you could have done something differently to increase your chances for award. And, like most of these things, the government's not going to respond in the way you would really like, but you just never know. And so ask the question. Don't ask, don't get. Next slide. Again, other things that you might consider, some of which are loaded questions, others are just questions. How many offers did the agency receive? That's usually in an offer letter, notice of award letter. The communications are important because there are rules about what the government can communicate with offerors about. And if they're clarifications, that gives an offeror some rights, but if they're discussions, there are other rights. So, knowing what kind of communication, or if there were communications, is a good basis for a possible protest. Some of these things, again, aren't so important. How many evaluators? What are the background of the evaluators? Were they replaced? Generally the government shies away from more personal questions like that, but you just, like I said, never know. Next slide. More of these questions. Did they know the identity of the offerors? Well, why that may be important, I don't know. Is there any bias? That's usually a real loser protest, but there might be some conflict that you wouldn't have known about unless you knew the identity of the evaluators. An independent government cost estimate. Very important question when you're talking about cost realism, because that's generally the benchmark. The government probably is not going to give you what that amount was, what the estimate was, but you could ask questions about how did they develop it. Did they use historical data? Did they, look at data from other contracts? How did the agency use the IGCE? These are questions that really go to the process that the government should answer. They're reasonable, but often the government doesn't answer. But it doesn't mean you don't ask them. And these are all the type of questions that I see in records of protests. Things that I see that may or may not make difference, but there are times where the SSA, the Source Selection Authority, doesn't accept the recommendations of the evaluators. What does that mean if the awardee received the award based on the Source Selection Authority, but that award is not supported by the technical evaluation team? So those are things that are good to know. Did they, if the Source Selection Authority did indeed ignore the technical report, did the Source Selection Authority actually read the proposals? Did he or she actually conduct a technical trade-off? GAO case law actually doesn't require agencies to do that best value technical trade-off if the awardee is a higher rated, lower priced awardee, offeror. So it's good to know that as well. And then, there is this concept of notwithstanding the ratings or the labels, did the Source Selection Authority ultimately consider them technically equal? And the importance of that is that means that price could have been the discriminating or deciding factor in the source selection decision. Next slide. These are questions about the evaluation of the awardee's proposal. Some of these are completely appropriate because in answering them, the agency is not disclosing proprietary information. They're only disclosing information regarding procurement and the process. But these type of questions, if they answer these type of questions, then the disappointed offeror, the debriefed offeror, is going to have a lot of information on which to decide the protest. So, the scoring of the technical and past performance proposals, any adjustments that they made, how many significant weaknesses, deficiencies. You're not asking what they were, but you're just asking to know whether there were any that were identified. Did the awardee have all the proposed licenses, certifications, educational background? You expect the government to say yes, of course, but on occasion, you might get the agency saying, what license? What are you talking about? And, or certification. And then, they go back and suddenly, that there's corrective action. Next slide. So here are the best practices that I've listed in my experience. Always ask for a debriefing, even if you're the awardee. I mean, that sort of gives you a sense of what the government's going to say to others, and you might, point out pitfalls right away or know what your relevant strengths might be to a protest. Always ask questions. I mean, as I said, you don't know if the agency is going to answer them, but it's important, just think them out. And if you have a question, there's nothing to be lost by asking it. If you are in person or on the phone, don't argue. They say that same thing to lawyers in depositions. Don't argue. If you argue, then they're going to clam up and they're not going to provide any information. And the role here is to be information gathering. So you want to ask full and open questions. You want the tone to be cooperative, and you want to be professional. Always ask for a copy of the evaluation documents or the source selection decision. Acknowledge that it needs to be redacted, but there might be a word or two or a sentence or two that the agency didn't disclose in their written debriefing or their oral debriefing. And if it's redacted, again, there's no reason why the agency wouldn't provide that to you other than they're scared you're going to protest. Ask your lawyer for developing questions. I hope when you saw the questions that I, off the top of my head wrote down, that these are some questions you wouldn't have thought of asking. So I think it's important to consult your lawyer because your lawyer knows the bid protest grounds that are common, and your lawyer knows when she sees the record of procurements, the kind of mistakes that can be made. So a lawyer can really help you draft questions that are pointed that you may not think are important or never thought were relevant. However, leave your lawyer at home. Again, you want the agency to be open, to tell you as much as they want. If you're aggressive or not very nice, they're going to clam up. And if they have a lawyer, they're going to clam up, or at least they're going to have their lawyer there, and then everybody clams up. So have a lawyer behind the scenes assisting you with developing questions, focusing you on the areas that you need to explore further, even tone, who should go. There are a lot of strategy issues you can lose a lawyer for, but once you walk in the door or you get on the phone, make sure your lawyer is out of sight. That's it for me, and I hope you learned something you didn't know before you logged on. Thanks very much.
Thank you so much for joining us today. And if you have any questions, please email her at the email or call her phone number shown on your screen. And this concludes the webinar. Thank you.